Good morning. I'd like to welcome you all to today's webinar where we will discuss the new data legislation, GDPR, and how it will affect the way we work. My name is Ellie Donoghue, and with me here I have Anne Wisser, who will be doing today's presentation. This will last around 30 minutes and will give an overview of the changes in data protection with the introduction of GDPR. During the presentation, we'll keep your lines muted, but you can send questions to us via the questions box on the sidebar. Following Anne's presentation, Richard Gravestock will then be running a Q&A session where he'll answer all your questions. And finally, running the technical side of things, we have Maria Jaeger. So to make sure you get the most out of this webinar, we'll provide you with a recording after the session, so you can view it again at your own leisure. You'll receive this all via email after the webinar, so there's no need for you to take notes, just sit back and enjoy the presentation. So before we make a start, we'd love to get to know you all a bit better. So we prepared some questions to see what stage you're at with GDPR, and we'd really appreciate if you could take the time to answer these, please. So there's just two questions which will pop up on your screen. Maria, can you please launch the first question? So our first question is, how far has your organisation got with GDPR? And we have three options here. So we're starting now with this webinar, or we're already compliant, or we've taken some steps but we've still got more work to do. So if you could all please just tick the box that applies to you. Okay, so we can see some of your votes coming in. We'll just wait a little bit longer for a few more to come through. Okay, Maria, if you can now close that survey and let's have a look at the results. Okay, so we can see we've got quite a mixture here, but so we can see some of you have made a start, but you've still got more work to do. So ultimately, well done for anyone that's logged into this webinar because you're on the right track. Okay, so Maria, can you please now launch the second question? So we would now like to know, what is your role in your organisation? So are you senior management, middle management, or a staff member? So again, please just tick the box that applies to you. And we can see all those results coming through. Okay, that's great. I think that's most of them in now. Maria, if you could just close the survey. Okay, so quite a few of you from senior and middle management are with us today. So I suspect a few data controllers. Okay, so thank you all for answering those questions. It's always good to get a feel for where you all are in the process. So we're really happy so many of you have taken the time to be with us today. So let's get down to business, and I'll now hand you over to Anne. Okay, so we appear to have lost connection with Anne's microphone, so Richard Gravestock is going to be taking the presentation instead. So Richard, over to you.
Thanks for that, Ellie. Sorry about that. We did do lots of practicing this morning, but obviously it's decided not to work today. The purpose of today's seminar is threefold, really. Firstly, we'll look at GDPR and the reason why it was introduced. Secondly, we'll provide you with an overview of the changes in data protection legislation. And we'll close by giving you an idea of the implications that this will have for your organisation and what actions you need to take. Just before we start the presentation, I just need to stress that the information given in this webinar represents the opinions of Batalas, and this information is based on our own experience of data protection and security and ISO management system standards such as 9001 and 27001, and we are hosting this webinar to help organisations to make sense of the information out there and to give some practical advice. So the deadline is the 25th of May 2018, and this is when all organisations need to comply with the new GDPR regulations. You now have 7 months and 7 days until the biggest change to the data protection law in what is probably a generation. If you're taking the time to watch this webinar, then you're probably already aware of the volume of work that needs to be done before the deadline. You may already know that you need to get top buy-in from top management, your board, and your organization in general. And how will this be achieved is something we'll need to consider. Before we look at GDPR, let's recap what legislation we have today, which is the Data Protection Act 1998. This is the UK Act of Parliament designed to protect personal data stored on computers and in filing systems. It controls how your personal information is used by organisations, businesses and governments alike. This is based around 8 protection principles, which, if you bear with me, I'll run through shortly. So the first we have is personal data, which must be processed fairly and lawfully. And this means adhering to the principles and requirements of the Data Protection Act. It also needs to be obtained for limited purposes, which means you're only acquiring information for the purposes you have indicated. The personal data must be adequate and relevant, but not excessive. So you can't ask for information that you don't need. You will need to monitor and manage your records and databases so that the data is kept accurate and up to date. And when you no longer need the data, you must delete it, so you don't keep it longer than necessary. The data must be processed in line with the rights of data subjects under the Data Protection Act, which is a recognition of the individual's right for privacy. You need to avoid loss, destruction and damage to personal data by implementing organisational and technical measures, which can include having appropriate policies and procedures in place, utilising things like encryption and password protection. Lastly, you must make sure the personal data is not transferred outside the European Economic Area without protection. And if you need to move the data, you must obtain permission to do so and take appropriate measures to secure it. We've had many companies contacting us saying, we have the data protection for years, so what's changing now? Well, here are the 3 main reasons for the change. Firstly, there were concerns about the lack of harmonisation across the EU, as the data protection laws differ slightly from country to country. So this has led to uncertainty and a lack of confidence among interested parties. Secondly, there was a belief that the data protection laws need strengthening to provide greater protection for the individuals. And thirdly, times are changing, and as you know, if we don't move with them, we'll all be left behind. The Data Protection Act came out in 1998, and it'll be 20 years old when GDPR takes over, and boy hasn't the world changed a lot since that time. So let's take a look down memory lane. Only 10% of the population in the UK had internet access. The EU agree on a single currency called the euro, and the European Central Bank is established. Windows 98 is released. Wow, I remember that. So Windows 98 was released. Google is founded in this year. That's quite an amazing thing. And then Apple unveils the iMac for the very first time. That gives you an idea of quite how long ago this was released. So now we have over 80% of the population with internet access in the UK. We have cloud computing, smartphones, social media. If data protection is to be kept up with at all times, it needs to be updated to meet the world that we live in now. So for instance, did you know that when we define personal data, we must now include IP addresses and mobile device identifiers? These are regarded as personally identifiable information, or PII for short. We live in the world of big data, where personal information is vast and is used as currencies. Companies trade in buying and selling your personal information, so we need to have legislation in place to protect it. While the Data Protection Act 1988 applied to the UK only, GDPR applies to the entire EU, including global companies which hold data on EU citizens. And if you think that Brexit will change this, then think again. GDPR was agreed prior to the referendum and is therefore part of UK legislation. So, what is GDPR? It is basically the new legal framework in the EU that overrides the existing UK Data Protection Act 1998. In short, it contains more detail in existing requirements with some new requirements added that includes opt-in, not just opt-out, transparency, and reporting of breaches and incidents. We're moving towards a culture of privacy and information security. GDPR is an EU directive built on 8 principles and 8 rights, and they are the right to be informed, meaning to be honest and transparent with me. For instance, if you ask me for information, tell me about your intentions, like what you're going to do with the data, who will see it, how long you keep it for, and in what format, etc. We also have the right of access, meaning let me see what data of mine you have. So if you ask me what data you're storing, you'll need to tell me. It must be accessible and it must be secure. You also have the right to rectification, meaning something requires updating or correcting. If I ask you to update or correct something, I need to be confident you will have done so. You have the right to erasure, meaning as you don't need my data anymore, please delete it. If I said no longer interested in your products or services, if I no longer hold insurance with you, if I now have a bank with somebody else, you must get rid of my data. You also have the right to restrict processing, meaning you can do this, but not that. I'm happy to send me a newsletter, but not spam my inbox with all the other stuff. We also have the right to data portability, meaning allow me to transport and move my data to another system. For instance, if you swap your mobile provider, you can transfer your mobile number to the new provider. And we also have the right to object, meaning read me my privacy rights in order that I can say no. You must put a privacy statement on your website or in any other communications to me and use plain language. And then lastly, there's the rights related to automated decision making or profiling, meaning being able to challenge pre-programmed computerized systems and ask for a review. Please explain to me how your software determined I am not eligible for an interview, as I'm concerned it might not be fair. With the introduction of GDPR, organizations are being held accountable for their personal data records, and they must demonstrate compliance to this legislation. For most organizations, this means you must provide awareness training for all your staff. Every employee will need to be aware of what is expected of them, and this will no doubt take time. And you will need to keep records to prove your staff are competent. You may need to audit your processes to check that they are compliant with GDPR and regularly review the way they work. To overcome all this, it may be that you need to consider having a data protection officer or a DPO, but we'll come back to that later in the webinar. There are 5 points of what you need to do that I'd like to highlight today. So privacy policies that are clear and transparent, informing interested parties of their privacy rights. And let's look at a little case study. A company has a privacy statement on its website that needs updating. So because it has too much legal jargon in it, and hence it's not easy for the general public to understand, it will need to inform visitors of their new privacy rights under the new GDPR regulations. So policies need to be laid out in a clear and concise way for everyone to understand. You cannot have a 200-page small print document for customers to read or ignore. So obtaining clear consent or permission from individuals. Let's say that currently a company includes a pre-ticked box on its website which says that a monthly newsletter will now be sent upon completion of an order, and that receivers can always state later that they no longer wish to receive it. Under GDPR, they must get a positive indication that the customer or prospect wants to receive the newsletter, meaning they must tick the boxes themselves. And for you as a company, you need to be able to provide evidence that consent has been given. This may take some engineering to do, and you might have to reduce more logs from your web apps, etc. The risk approach. The first thing a regulator will ask for if you suffer a data breach and they come knocking at your door is your DPIA, which is your Data Protection Impact Assessment. It is your audit trail and the evidence that they would want to see. So companies should do this exercise. Say a company is dealing with the risk data like a healthcare consultancy, a law firm, a research agency, where risk of privacy breach is greater and more damaging. Then they will need to conduct the impact assessment, categorize the data risks, and the level of risk attached to each category and how they are currently protecting that data. As a result, they may need to implement stronger controls. And if a company believes it is not dealing with the risk data, an impact assessment is still considered good practice. This technique is used in things like ISO 27001:2013, the international standard for information security. There are many ways to disguise or codify personal data to reduce the risk of a breach. A company would typically use codes to represent information about someone's age or health, for instance, so that it did not fall into the wrong hands. The risk of someone discovering someone's sensitive information is much lower. But be aware that you need to be able to reverse the process. In the event of a subject access request, you need to be able to turn that information back into understandable information for the subject and the format again. This poses a problem, as the technology at the moment is nowhere near or accessible as, say, encryption technology, which is widely available. Keeping records of processing activities has always been considered good practice. Under the new GDPR, if you're a large company or a company processing large amounts of data, detailed records keeping will be mandatory. For SMEs, small to medium enterprises, this will need to be carried out for high-risk data categories. It will be highly advisable to ensure that data management processes are embedded into the business processes themselves. A company which has something like ISO 9001 quality management systems will find that they can do this by reviewing the clauses of the standard that are relevant to data protection. Also, ISO 27001 specializes in the design of information security management systems, which is something companies could implement to help with data protection. Data lifecycle management will include the creation or receipt, storage, usage, movement or sharing, archiving and secure destruction of your data. Retention of personal data. If you hold personal data, most companies hold at least the data of their staff. You will need to define how long you will keep this data for and how it will be destroyed. The destruction of personal data. Data destruction is a complex task, so you will need to ensure you have access to IT specialists to do this. Categories of data and user recipient groups. This relates to our earlier point about designing a classification system that defines categories of data. Establish rules for each category or group. After that is done, you can establish procedures for each category, taking the risk level of each category into account. Encryption. Use suitable encryption. You may have to consult an IT specialist as required by you and or your client or other interested parties. Access. In the old Data Protection Act, fees applied if people wanted to gain access to their data. Individuals can now gain access to their personal or sensitive data for free, and it will need to be carried out within 1 month. So in the old days, we might put in a little fee for people having their data back, but now we can't do that if it's electronic. Life cycle perspective. This relates to our previous point about tracking data from its creation or receipt all the way through to its destruction. You will need to know exactly where your data is and where the backups are so that you can enforce secure destruction with confidence, as per your data retention policy or if requested by an interested party. And then there's the opt-in, not opt-out. This relates to our previous point about you needing to gain positive intent of permission to send out information. And then lastly, we have CCTV. The information held on CCTV systems is potentially personal or sensitive. You must have a legitimate reason for using CCTV, and the data must be treated in the same way as examples mentioned in previous, in terms of secure storage, retention, and destruction. So to be able to look after all of this, you may consider having a data protection officer or someone that can take the role as part of their job. But before we move on with the presentation, we'd like to hear from you again, so I'll hand you back to Ellie for a little while.
Thank you, Richard. So the introduction of a data protection officer is one of the main features of GDPR. So we'd like to find out if any of you have a DPO in your organisation already. So Maria, can you please launch the survey? Okay, so if you can answer this question, have you got a data protection officer in your organisation? And then we've got 5 options here. So yes, it's me. Yes, it's someone else. No, but we're planning to have one. No, or not applicable. So if you could all just tick the box that applies to you, please. Okay, that's great. So we can see the votes coming in. We'll leave that running just a little bit longer. Okay, Maria, if you can just close that survey now, let's have a look at those results. Okay, that's interesting. So we've got quite a mixture there. Well, mostly no is the response there, which is really interesting. So thank you all for your answers. I'll now hand you back over to Richard, who will continue with the presentation.
So if we look at the data protection officer, in this case, they will need to educate and advise the organisation. Sorry, apologies about that. I have the wrong slide in front of me. If we go back to the data protection previous slide, thank you. It could be that you already have an information security officer or a head of compliance or a quality manager perhaps, or someone in your company who works with regulations and laws, perhaps your compliance manager, and they might be suitable to take on the work of ensuring that your organisation complies with the legislation. But please be aware that there must not be a conflict of interest if the person has more than one role in the company. For example, if your DPO is the IT operations manager, that shouldn't be allowed. This has already been tested in German courts recently, so keep in mind when appointing your DPO. Please also be aware that it is mandatory to have have a DPO if you're a public authority or a government agency, or if you carry out large-scale systematic monitoring of individuals. So for example, if you're tracking online behaviour, or if you carry out large-scale processing of special categories of data, or data relating to criminal convictions and offences. But if your organisation falls into any of these categories, chances are you probably already have someone looking after that role. If not, you're probably running out of time. So if we, next slide, thank you. They will need to educate and advise the organisation and its employees about the legislation. The DPO needs to clearly understand GDPR, keeping themselves up to date with developments, and advise managers accordingly. This could involve the running of workshops, webinars, or training courses, for example. They will also monitor compliance with GDPR, possibly auditing against the requirements. The DPO will be responsible for providing information to top management as to whether or not the company is complying with GDPR. Internal auditing may be a good way of doing this, and if you're already running an internal audit program, for example, based on 9001 or 27001, then this can be woven into this system automatically. DPOs are the first and main point of contact for all matters relating to GDPR. Interested parties inside and outside the company will need a point of contact for inquiries or complaints, including the ICO or any other external body. They report to top management. The DPO must report to the board or an equivalent. They will interact with other key roles, for instance, the quality director or HR or IT or any other compliance heads. And they will also be responsible for reporting incident breaches. As an organisation, you need to have the right processes and procedures in place to detect, report, and investigate personal data breaches. This is often the data protection officer who will carry out this task. But what do we mean by personal data breach? The Information Commissioner's Office, or ICO for short, has defined it as follows. A personal data breach means a breach of security leading to the destruction, loss, alteration, unauthorized disclosure of, or access to personal data. This means a breach is more than just losing personal data. For example, a hospital could be responsible for personal data breach if a patient's health record is inappropriately accessed due to a lack of appropriate internal controls. When you become aware of a breach of this kind, you have 72 hours to notify the relevant supervisory authority. You are allowed more time to investigate the breach fully, but they need to be told within 72 hours. You can then provide further information in stages. If you fail to report such a breach, there are fines of up to 10 million euros or 2% of the global turnover. So for example, a company who has a turnover of 2 million a year, the fine is 40,000 euros. So if your turnover is 100 million euros, then we can see the fine is just going to go up and up and up. So it's quite a costly exercise not to report a security breach. Once you've reported the breach, the regulator will look at the evidence and decide if you have done what you could to prevent it happening in the first place. If you haven't, say you haven't trained your staff properly or you don't have process for data retention, you can get fined up to 20 million euros or, again, 4% this time, of global turnover. But let's not worry about that. You're here to learn how to avoid data breaches, not get fined. It's worth noting that you may never guarantee that you don't have a data breach. It's almost inevitable. This does not, however, mean that you'll be hit with a fine worth millions of euros. In fact, far from it. If the regulator finds that you followed the guidelines, you can provide them with tangible evidence, that you took reasonable precautions to limit the risk, you did your DPIAs, you have a nominated DPO, you've trained your staff, you had top level buy-in, then perhaps you may not incur a fine at all, or at least not the maximum fine. If you're feeling a little bit daunted by all of this, don't worry, there are steps that you can take right now. You can embrace the opportunities to improve. If we see GDPR as an opportunity to improve your business, of course, it's easy to focus on the negative of security breaches. But if we utilize the time you have available to make the right changes, get your data house in order, spring clean, chuck out some of the old stuff you don't need, and when you've got it right, boast about it. It may even give you a competitive edge. If we avoid the pitfalls, we must be aware of the risks and act to avoid them now. You don't want to be spending thousands of euros on fines. Before you get away with a slap on the wrist, before you could get away with a slap on the wrist, but now you have to pay a very hefty fine for breaches with this new legislation. A bit of appropriate risk-based thinking will go a long way to avoid this, which is something we teach in our information security courses. And then there's recycling and upcycling. If you already have measures in place to train people in the existing Data Protection Act, then you already have a head start. You will, of course, need to make some changes, but you can use a lot of the same processes as you do now. They just need to be brought up to date with the new laws. If we invest in people, people are key. If you invest in the people processing the data in your company, your staff, you're more likely to achieve compliance and avoid a breach. You need to train your staff, do a gap analysis of their knowledge and make sure the gaps are closed. That way you can avoid the negative risks and take advantage of all the opportunities. The good old phrase, training makes perfect. Try to avoid GDPR becoming a tick box exercise. Make the training you provide for your staff engaging and focus on staff gaining understanding. Reading long documents of heavy wording may not be the best way of training this stuff. John Cleese famously said, "People learn nothing when they are asleep and very little when they are bored." If you're not confident on delivering the training yourself, you can find a training provider who is willing to work with you and tailor this training to you and your organization. That's the end of the presentation. Apologies that Anne's microphone wasn't working earlier. Slight technical hitch, but as I say, that's the end of the presentation. I hope it gives you a little insight into what you can do right now. Sometimes just taking that first step can be the hardest, but by joining us today, you've already made that step. I'm going to now hand you back over to Ellie, who will start the Q&As.
Many thanks, Richard. That was a great presentation on the changes to data protection legislation. This is going to have a major impact on the way we all work with data in the workplace. So throughout the presentation, we've been receiving lots of questions, so this topic has clearly got you all thinking. So Richard and I will now run through these. We might not have time to cover them all, but don't worry. We'll contact you via email after the session if yours doesn't get answered. So it could be that some of these topics have already been covered in the presentation. So Maria, whilst we're going through the questions, if we've got any relevant slides, would you mind just bringing these up, please? Thank you. Okay, so let's make a start. Richard, the first question is, I run a small business and we can't warrant a DPO. Can anyone internally do this role, and how much of their time would it take?
That's a really good question. Thanks, Ellie. The first thing to probably remember is that it's not mandatory to have a DPO if your business has less than 250 employees. But I'd probably say it's logical that in any business you will already have that person that's looking after your data protection in general, as we mentioned in the presentation. You've got to bear in mind, though, if that person that's doing it at the moment doesn't have any previous experience or knowledge of the data protection, the new GDPR regulations, I think it's going to be quite a steep learning curve. So how long will it take? I think was another question I just saw to get this DPO up to date, and that's another hard question. Typically, changes such as these, there's quite a lot of work to start with, but obviously as the time goes on, the system beds in, it becomes less. So I think you need to sort of do a gap analysis of what you need to do to get the DPO in the first place.
Okay, fantastic. Thanks, Richard. So moving on to our next question. I have several databases which I've purchased from a data house. Can I still use them after May the 25th, 2018? And is there anything I can do before this date to get these people onto my main mailing list? Now, I suspect this question will apply to quite a lot of people. So what's your answer to this one, Richard?
Oh, that is probably the hottest topic that I read on a daily basis now in GDPR terms. And it's a topic that seems to have many different answers and never the same one. If you bought the data genuinely and it was for your own research and they asked to subscribe to your newsletter, whatever you want to call it, before the 25th of May, and that was actually information harvest for yourself, there's an argument that as long as they are currently opening data at the moment, then yes, you could probably use that database. Certainly if the database was bought as a general database with just the names and addresses of IT managers or directors or whatever in a certain area, it's questionable whether they actually opted in. So I would probably always suggest going back to the data house that you bought this data from and asking them specifically, does this comply with GDPR? I get some assurances, because if you remember what we said in the presentation, it's all about evidence. If the ICO come in and investigate you and find that you haven't got this evidence in place, if you've got a lovely letter off the data house, a reputable data house saying that it's GDPR compliant, then that's probably the easiest answer for that one.
Great, thanks, Richard. So moving on to our next question we have here. So when I make a sale, I take personal details and marketing consent over the phone. How do I prove this?
Well, all you can probably do is make doubly sure really that the other party is clear on what you're trying to do and how you're going to keep a record of it. So again, going back to if we keep records and evidence of proof of how you obtained all the data and how you're going to use it, then things like that are very important, but often overlooked in today's modern business.
Okay, thank you. Our next question we have in is, do I need to add anything to my business T's and C's to hold data?
Oh, another hot topic on that one. I think at the moment, because of the fact that this document actually, the new GDPR is actually still a working document, and I think the best thing is probably to take legal advice on your T's and C's. Obviously, I would guess most of your T's and C's are already worked on by a legal team. Therefore, I'd advise them to modify and adapt to that accordingly.
Okay, so our next question we have in is if someone opts in for marketing consent, do I need to send them a follow-up email for them to confirm? So this would be, you know, like a tick box on an email.
No. At the end of the day, they've already opted in, so they've ticked the box in the first place. So as long as they're actively consenting, i.e. pressing a button on a website saying, you know, ticking a box saying, yes, I wish to opt in, and then say submit, that's absolutely fine. But is what you must do in the future is every communication you have with them, in whatever format it might be, you must make sure you have an opt-out facility in any kind of future communications.
Okay, so that might be like an unsubscribe button at the bottom of an email.
Absolutely, yeah, something like that, yeah.
Okay, that's great. So we have a question here from a consultant, and they're saying, I work with several different companies. Am I allowed to use their data still? So who is accountable for compliance? Would that be the consultant or the company they work for?
Oh, another tricky question, I think. I think if you sort of look at the word data owner and data processor, those definitions on the ICO website, which we'll put up a link later in the information we send to you, but the ICO website has definitions for something called the data owner and the data processor. There's also one for data controller, but if we take owner and processor, those are the ones that I think you really need to look at and see whether you fit into which side of that, and then that will give you an idea from the ICO website.
Okay, thank you. We've got another question here, which again I think a lot of people will be asking. So is there a time limit for how long I can hold data?
Not really. It's actually defined probably by your customers or your board or the owners or any other regulatory body. You are advised to define probably a reasonable retention period for these policies that just helps to justify or explain how those retention policies work.
Okay, now we've got one here from someone who's asking, who are ICO?
That is the Information Commissioner's Offices. They are, for example, the UK's independent body set up to uphold information rights in the UK.
Great. So our next one here, it relates to auditing. We've got someone asking, will I get audited on how they hold and use their data?
That's always possible, absolutely. We would always strongly advise as an organisation to carry out internal auditing. At the end of the day, how else are you going to prove to anyone internally or externally that you're following the regulations? And that goes for these regulations as well as any other frameworks that you have internally.
Okay, so our next question we have here is someone asking, what constitutes as personal data?
Oh, any kind of private information, sort of that's to the private individual. Things like names, addresses, mobile numbers, landline numbers, postcodes, IP addresses. There's even something called a mobile device identifier where they can track what your mobile is and who you are from it. Even things as far as photographs or videos. And then when you move on to sort of modern day stuff, some of the fingerprints and facial recognition software out there, all those things at the end of the day can help identify you. And you've got to remember that if you've got more than one of those pieces of information, that is quite a strong way of identifying who you are. So yeah, you've just got to list all of that really.
Okay, so there's an interesting question we've had in from someone asking, do I have to treat personal data differently to business data? So this would be perhaps someone using an email address with like a Yahoo or a Hotmail email.
It's probably fair to assume that something like Yahoo, Hotmail, Gmail traditionally is a private email address. I would say it is, personally. I think most people agree with me. So if that's the case, yes, it's almost certainly personal data. A business address, for example, batalas.com, that isn't personal data because that's in the public domain. So my email address is somewhere in the public domain, therefore is it personal data? So, but I would say definitely a Hotmail or Gmail address is personal data. Therefore you've got to keep that secure.
Okay, thank you. So our next one is someone asking, so their client data is from consumers. They've been using it for over 10 years. They're saying, I can't prove consent, so does this mean I can't use it anymore?
It really depends on how you want to use that information. If you go back to the earlier question, I think maybe question 2 was it, regarding what you're going to use your data for in the first place, is probably the best answer to that one.
Okay, thank you, Richard. So we've got a question in from someone who works in finance, and they're saying that they store their invoices in folders, so not electronically, this is physical folders, and they're asking how do they protect this?
That's a really good question. Thank you, whoever asked that. We're all concentrating on electronic data and not physical folders and files. We've all got files and folders and things like that dotted around our office. I can see some dotted around our office now. You've just got to think about this reasonably. A locked door, key management, so who's got access to the keys, even a door entry system. You've got to think of your physical folders and files around your office just as much as you do your electronic. So just think about who's got access to those from the outside world. Can they get past the receptionist and get that data? It's all covered under the same thing.
Okay, so we have a question from someone asking, what classes as legitimate interest for holding data?
It's really having a justifiable reason to hold that data. So, for example, if you want to send product information to a regular paying customer, that would be a legitimate reason.
Okay, so our next question is someone asking, as part of my business, I need to forward my client's data to a third party. Am I allowed to do this?
I would say there's 2 ways to answer that. Always better to check with the client first because it is their data at the end of the day, but you've also got to remember that we all have contracts in place with our clients and our suppliers, and it may already be in those contractual documents that you have something already in one of the clauses that says that you're allowed to use that data. So if it's in that contract, probably no need to ask, but you know, they are a client, it's probably better to ask them.
Okay, fantastic. So we've got a really interesting question here from someone who's saying that they've actually had a data breach previously, and they're asking, do they need to report this to the ICO even though it would have been prior to the 25th of May 2018? So how would you answer that, Richard?
If I understand the question rightly, that was right. Okay, yeah. Sorry, yeah. Sorry, with you now. If it's a serious breach, I would advise yes. They're not going to tell you off for it because with the data protection as it was, with the GDPR coming in, yeah, I mean, it depends what you class as serious, but I would say, yeah, if it's a serious enough case, be open and transparent. That's part of what they're trying to get us to be. If you're open and transparent throughout the whole process, then yes, it's probably better to advise on that.
Okay, fantastic. Thanks, Richard. I think that's we managed to get through quite a few questions, and I think that's enough for today. If you've sent us a question and we haven't had time to answer, then don't worry, we'll send you an email after the session. I hope you found this presentation helpful on your path to GDPR compliance. I'd like to thank you all for joining us today.
Yeah, thank you for listening. Sorry about the technical issues at the start. I'm just looking at all the questions now, and there are so many coming through. We're just never going to get time to answer them all. We have a lot of technical expertise at this end, which we will look at all the various questions and reply to you all. It may take a few days, so apologies because of the volume of questions, but we will. And you can keep asking them away now, or if you have a question, you can just get in touch with somebody in the office. Just reach out to us, and we're more than happy to help. Thank you very much for everyone that joined us today, and hope to speak to you all soon.